In the last class on Friday, we discussed Article 20, Article 21, and then we also looked at Article 21, capital A, and then we discussed previous year's question papers. Today, let's talk about Article 22, and then we are done with this category, right to freedom. Then we will look at Articles 23 and 24, which deal with right against exploitation. Then we will talk about four important fundamental rights with respect to freedom of religion, 25 to 28. Then cultural and educational rights under Articles 29 and 30. Then Article 31 we will skip. Why? Because we will discuss this in Directive Principles of State Policy. We will then look at Article 32 and then few other articles under Part 3 of the Constitution. Then we will look at some of the constitutional bodies which you should remember through this part of the Constitution. And then tomorrow, hopefully, we will begin with Directive Principles of State Policy. Let's look at Article 22, protection against arrest and detention, but in certain cases, which means you do not have or nobody has a fundamental right against arrest because you can be arrested. Because right to life and personal liberty is not an absolute fundamental right. Whenever you violate the law, if the procedure established by law is followed, which basically is due process of law after the 1978 Maneka Gandhi judgment, your right to life and personal liberty can be violated, which means you can be arrested, you can be detained. But even after you are detained, there is still a fundamental right which kicks in. That means this Article 22 comes into the picture after an individual has been arrested. And after an individual has been arrested, this Article 22 comes into the picture, but this is a fundamental right which is not available to enemy aliens. That means this fundamental right is available to citizens as well as aliens, but not to enemy aliens. And who are these enemy aliens? Aliens can be divided into friendly and enemy aliens. Friendly aliens are the citizens of those countries which share cordial, good relations with India. Enemy aliens are the citizens of those countries with which India is at war. And those citizens of countries, those nationals of other countries with which India is at war, if they are in India, they do not enjoy this protection under Article 22 of the Constitution. And what is Article 22? No person who is arrested shall be detained in the custody without being informed. That means I have a fundamental right to be informed of the grounds on which I'm being arrested. I'm taking a class right now. There's a knock at the door. The police party comes. They want to arrest me, but I have the right to know on what grounds. Are the grounds terrorism? Are the grounds murder? Are the grounds waging war against the country? Are the grounds theft? Are the grounds forgery? What are these grounds on the basis of which I am being arrested? I want to know that. I need to know that. This is my fundamental right. So that I can call my lawyer. I can set up my legal defense. So that my lawyer can approach the judiciary and ask for bail. This right to be informed of the grounds on which you are being arrested, this is my fundamental right, available to citizens, available to aliens, except enemy aliens. Similarly, every person who is being detained shall be produced before the nearest magistrate within a period of 24 hours. Now, to prevent arbitrary arrests by the police, arbitrary arrest on weak grounds, on illogical grounds, there is a particular police inspector who does not like you, or you have got some issues with each other, but because he has power, he comes and arrests you. But within 24 hours, I am to be produced before the court, before the nearest magistrate. And now the magistrate would look at the grounds. On what grounds is he being arrested? Has he committed any crime or not? If yes, then this individual will either be sent to judicial custody or police custody. When I am arrested, within 24 hours of my arrest, I am produced before the judge. And judge will be informed what are the charges against this individual. The charges are, let's say, terrorism, waging war against the country, or the charges can be theft. Both are crimes, but one is a slightly lesser crime, the other is slightly bigger crime. And now, if I'm being arrested on the grounds of terrorism, on the grounds of waging war against the country, I will be sent to police custody. The judge will say this person is sent to police remand for 14 days or 1 month, whatever the case may be, so that in custody, the police will investigate, the police will interrogate me. Interrogation does not mean the kind of interrogation that you see in Bollywood movies, where you're tortured inside the jail. You can't be tortured. Yes, there have been instances where people in custody have been tortured, but that is a violation. For that, you can go to the court. You can be investigated, you can be interrogated, you may be asked questions, you may be asked for evidence, you may be asked about who gave you the weapons, who is involved, so that the police has ample time to investigate this case, produce a solid charge sheet before the court, and through this charge sheet, you can be prosecuted. But if it is theft, there is no need for the police to conduct further investigation because they know that there is a case of theft. This person is involved. They already have the evidence. There is no need to interrogate this individual. And in this case, the court will say this person is sent to judicial custody, where you are sent to jail. In police custody, you are sent to police station, police lockup. And in jail, without the permission by the court, the police cannot interrogate you. That's the difference between police custody and the judicial custody. And this question has been asked in your prelims examination. Which means I have a fundamental right to be informed of the grounds I'm being arrested for. And once I'm arrested, within 24 hours, I am to be produced before the nearest magistrate, nearest judge, so that this magistrate can then decide, based on the merits of this case, based on the charges of this case, based on the nature of the allegations against me, whether to send me to police custody or to judicial custody. If I'm sent to police custody, that means police can interrogate me at any point in time. But if I'm sent to judicial custody, if the police has to interrogate me, they have to first take the permission of the court, then visit the jail to interrogate me. That's the difference between the two. Further, Supreme Court has expanded the scope of Article 22 and has said if a woman is to be arrested, as much as possible, this woman should not be arrested before sunrise and after sunset. And whenever this woman is to be arrested, woman constables shall be present. Article 22, protection from arrest and detention in certain cases, which means this is not a fundamental right against arrest. You do not have a fundamental right which says you can't be arrested under any case, under any circumstance. This fundamental right comes into the picture after an individual has been arrested. After an individual has been arrested, you need to inform this individual of the grounds on which you are being arrested. For example, whether you have seen this or not, when Arnab Goswami was being arrested, when the police party reached the residence of Arnab Goswami, Ultimately, he was told that these are the grounds on which you are being arrested. His wife was also presented. A paper was given to this wife that these are the charges against you, against your husband. Please sign on this. Why? Because so that tomorrow, if Mr. Goswami claims in the court that I was not informed of the grounds on which I was arrested, we can show this document before the judge saying this is duly signed by the wife of this journalist, because we informed at the time of the arrest that these are the allegations against you, these are the charges against you. And within 24 hours, Mr. Goswami was produced before the nearest magistrate. And then, if you would have watched those videos, he cried a lot and said, Taloja, Taloja, Taloja. That means he was telling his crew, he was telling his journalists that I'm being sent to Taloja jail, because he was sent to the judicial custody. Clear? Inform of the grounds on which you are being arrested. Be produced before the court within 24 hours of your arrest. But at the same time, the court has expanded the scope of Article 22. Just like the court has expanded the scope of Article 19, Article 21. And the court has said if a woman is to be arrested, as much as possible, which means not in every case, but as much as possible, ensure that a woman is not arrested before sunrise and after sunset. And whenever a woman is to be arrested, a woman constable should also be present. But this is as much as possible. If a woman is under flight risk, that means if we don't arrest this woman right now, she may leave this country or she may threaten the witness. Then we can arrest, the police can arrest this woman even after sunrise, even before sunset. And the court has further said, jail is an exception bail is the norm. Justice Krishna Iyer, Justice Bhagwati, in the late 1970s, they gave a beautiful judgment wherein they said jail is an exception, bail is the norm. Golden rule of criminal justice system, which we have been discussing repeatedly. You are innocent until proven otherwise. I may be arrested in a particular case, but I'm innocent unless and until the court says you are guilty. But judicial process is a slow process in India. That means the cases may take many years. There have also been instances where a case would continue for 20 years, till the time a petitioner is already dead. Imagine a situation where you are accused in a particular case and you're thrown into a jail. And it takes 20 years for the judiciary to decide that you are innocent. What will happen to the 20 years of your life? They're gone, they're lost. Since the assumption is that you are innocent until proven guilty, you are innocent until proven otherwise, jail should be an exception. Only in exceptional circumstances you should be sent to jail. Otherwise, you should be released on bail. Bail in the sense, I may give up my passport. In a sense, I will surrender my passport before the court, saying that I have no reason to run away from this country. The passport is with you. I will cooperate with the police. Whenever the police asks for my presence, I will be present before the police, before the court. I will involve myself, participate, engage, and cooperate with the investigation. But release me on bail. Because if I'm sentenced to jail, if I'm kept in jail, what if after a few years I'm proved innocent? All those years cannot be restored to me. But the court has said jail is an exception. Exception in what cases? When an individual is at flight risk. Arrest this person, send him to jail because he's at a flight risk. He has a lot of contacts, and through these contacts, he can run away from this country. This person should be in jail. Jail is an exception when this individual can threaten the witness. This particular individual is a Bahubali. He's a Gunda. He's a he has a criminal record as well. And now he is accused of murder. Since he has a lot of muscle power, money power, what this individual can do, he can threaten all those witnesses. Don't you dare give evidence against me, otherwise I will kill you. Or even before you will give evidence against me, I will kill you. So this particular individual has the potential to threaten the witnesses. Don't release him on bail, because if he is released on bail, he can threaten the witnesses, keep him in jail. Or if this individual can tamper the evidence. There is an evidence against this individual. Let's say the evidence is a murder weapon. What this individual can do, he can tamper with that murder evidence. He can make that murder evidence disappear. So this individual is at a flight risk, can threaten the witnesses, can tamper with the evidence. All these are exceptional grounds, extraordinary grounds on the basis of which you will be asked to remain in jail. Otherwise, you will be released on bail. That is Article 22 of the Constitution. But even this Article 22 is not an absolute fundamental right, which means all these protections are not available to some people. And who are these individuals? Those who are enemy aliens, as we have discussed previously, the citizens of those countries with which India is at war. And these protections are also not available to those who are under preventive detention laws. Detention is of two types. Either it's a preventive detention or it's a punitive detention. What is the difference? You have committed a crime, let's say the crime of murder. You're booked under Section 302 of Indian Penal Code. The case continued, and finally the court has said you are guilty. You're sentenced to 14 years in jail, for example. Those 14 years that you will serve in jail, that is part of your punishment. That means you are being punished for the crime that you have committed. For that, you are being detained in the jail. Those 14 years, you will be under punitive detention as part of your punishment. That means punitive detention comes into the picture after you are declared guilty. After the declaration of guilt. But imagine a different situation. I am an individual, I have a lot of following, for example, and tomorrow I decide to launch a protest against the government of India. And I'm telling my people, telling my supporters that we should burn buses, bridges, we should burn the public property, we should destroy public property. That means basically I am inciting people to violence. But not just that. Basically, when you commit a crime, after that you can be arrested. If you are only thinking of the crime, you will not be arrested. Because thinking about a crime is not a crime. It is only when you ultimately commit the crime that you will be arrested. In ideal situation. But we know for a fact, we know for sure that if this individual is allowed to take out this rally tomorrow, take out this procession tomorrow, public order will be violated. Buses and cars will be burnt. Public property would be destroyed. Should we let this fire engulf the entire city and then arrest this individual? Or should we not prevent the city from being burnt? Should we not prevent this crime from taking place? This is where preventive detention comes into the picture. That means you are being prevented from committing a crime. You are being prevented from violating the law. You have not violated a law. You have not committed any crime. But through these laws, we are preventing you from violating the law, from committing the crime. Those laws are what we call preventive detention laws. For example, National Security Act of 1980. Similarly, there is a law known as Public Safety Act, which is applicable only in Jammu and Kashmir. Although the special status for Jammu and Kashmir was revoked in 2019, but there exists some other special statuses. One such is Public Safety Act. For example, when Sheikh Abdullah was the initially the Prime Minister of Jammu and Kashmir, later on Chief Minister of Jammu and Kashmir, he got the legislature of Jammu and Kashmir pass a law known as Public Safety Act. We have to ensure public safety. And this act was particularly targeted at timber smugglers. So there were those who would smuggle the timber. For example, deodar trees would be felled, pine trees would be cut and then smuggled to different parts of the country, smuggled to different parts of the state as well. So to arrest those timber smugglers, before they could fell the tree, they could destroy the forest. That was the purpose of this law, Public Safety Act. But later on, this act got also applicable to those who would start throwing stones at the security forces. There is an individual who is a known stone pelter. That means this individual comes out of his home, takes the roads along with his colleagues. Ultimately, they start throwing stones at the security forces. Should we first let this individual throw stone at the police, at the security forces, and then arrest? Or should we, if we know that tomorrow there may be a protest, we will arrest this individual before, keep him in custody for 24 hours. After that event is over, we will release him. Because if we keep this individual out during that 24-hour period when there is an important event going on, for example, Home Minister is visiting the state, Prime Minister is visiting the state, and these individuals, they will come out, they will start throwing stones at the security forces. Should we let Now let's look at two other important fundamental rights under the category right against exploitation, which means first we need to provide equality to the people. Then we need to ensure that they have the freedom to do whatever they want to do. And at the same time, they should not also be exploited. Who are the groups in India which are being exploited a lot? Women, children, members of the SC and ST community, their exploitation is covered under Article 17. Abolition of untouchability. Untouchability is abolished. Judicial creativity and judicial activism. Kajal, that's something that we will discuss in judiciary. It is through judicial creativity that judiciary is practicing judicial activism. And we will discuss that. And see, if done publicly, yes. If done behind the closed doors, you have the right to privacy. You have the fundamental right to decide what you want to do. Because if it is not a fundamental right, if it's a legal right, that means tomorrow, through an ordinary law, the parliament may say that you may be detained and you should be produced before the nearest magistrate within 24,000 years. This should not happen. That's why it's a fundamental right. Can I file a case against my parents under Article 23 for forcing you to study? Forcing you to study is not an exploitation, my dear. So you can't file a case. For example, there used to be a law known as SITA, Suppression of Immoral Traffic Act. It was later changed to PITA, Prevention of Immoral Traffic Act. So that act prohibits traffic. Similarly, we have Bonded Labor Abolition Act that also prevents exploitation. We have multiple laws. 9, 10 students can be imposed compulsory service, and class 12 students cannot be imposed compulsory service. Class as an economic term. Class, upper class, those who are rich. Lower class, those who are poor. Upper class, those who are bourgeois, those who control the industries and factories. For example, Tatas, Birlas, Ambanis, Adanis. Those who are workers, blue collar workers, white collar workers. So while imposing compulsory service, the state cannot say that we are imposing this duty only on those who are working as class 4 employees in government and not the private sector presidents and chief executive officers. While imposing this duty, there can be no discrimination on class, on economic grounds. Violation. We will discuss Article 24. And also, when you write a question, write it in one comment. So half of the comment was in one comment, the next half was in different comments. So the one half was, "What are you?" Thought, "What is this?" And next comment was discussing. So, and this discussion, so when you wrote that question, after that there was 7, 8 other questions. And after that there was this term discussing. So then I could correlate. What are you discussing? So write it in one line, my dear. Child labor. What Article 24 thereby leading to the development of a child. This law is good because for the first time, the law takes into account the requirements of adolescents. This law is good as well because of now increased penalties. Because previously the penalty was 6 months, the penalty was 20,000 rupees fine. But now the penalty has been increased, 2 years in jail, 50,000 fine, or both. So increased penalties may also lead to better implementation of this law because people will be deterred from employing children in violation of this law because they will be sentenced to 2 years in jail or 50,000 fine will be imposed or both. This law is also good because this law ensures that even guardians can be prosecuted if they permit it. Because previously, what would happen is that these kids were pushed into employment by their guardians. And who this guardian can be? This child is an orphan, lost both her parents. But now this child is pushed into employment by her uncle, who is her guardian now, or by the grandfather, who is now her guardian. That means this child is being pushed into employment. But this guardian was not prosecuted. Only the employer was prosecuted. Now, even this guardian will be prosecuted if the court is convinced that they pushed these children into employment. So now it will be like a deterrent to the guardian. I cannot push these children to the employment. I have to send them to school. Otherwise, I will be prosecuted. All these provisions, all these important aspects highlight that this law is a good law because this ensures that we balance the rights of the child and we also ensure the creative development of a child by allowing the child to work, to be employed, to participate in audiovisual entertainment industry and as family business. That's the argument in favor of this law. But as we dig deeper, we see that there is a problem. What is the problem? This law allows child labor. How does this law allow child labor? First one, whether you like it or not, whether it is offensive or not, whether you will be offended or not, we are a patriarchal society. And when we are a patriarchal society, this law particularly affects the girl child. How does this law affect the girl child? For example, if you have a brother and a sister, male child and the female child, more attention is given to the male child. Better food, good dresses, nutritious food as well, and this girl child is neglected. In fact, we don't even want this girl child. We want to kill her in the womb itself. But there is a law which says prenatal sex determination is a crime. Otherwise, we would have killed her. And somehow, if she survives, we neglect her, we don't give her good education, we don't give her nutritious food. But then what we do, this girl will start going to a school less than the age of 14. Imagine the situation. This girl, less than the age of 14, will start her school 9 o'clock in the morning, for example. And then she is in school till 4 o'clock in the evening, right? But this girl can assist the family in the family business. Now this girl, she comes back to school, she comes back from school to home, and now she assists her mother. Her mother is a tailor. Maybe she's stitching the clothes. Maybe she's stitching collars on the shirts. And now, after school hours, this child is working and assisting her mother to in fixing these collars, in stitching these clothes. And then she's tired. She's not given nutritious food either because that is reserved for a male child. Where is her time for homework? Or forget about homework. After school hours, something else starts. Something beautiful starts. The childhood of an individual. Maybe she wants to play with the other kids in the neighborhood. Maybe she wants to explore other creative pursuits. But no, she's allowed to work and assist in family business after school hours. That means through this law, you're snatching the childhood. Not just this, this law creates a conducive atmosphere for surrogate business. What is surrogate business? I need cheap labor, and the cheapest labor is a child. I have a BD rolling business. I roll BDs. And I want to employ children. And I used to employ children. But now, because of this law, I cannot employ them. So, what do? I look at three families. This family has 8 children. This family has 6 children. This family has 7 children. So, 8, 7, 6, 21 children. What I do? I start a BD rolling business, and there are 3 owners of this business. They don't even know. When there are 3 owners of this business, I take their kids. Come, you are now assisting me in your own family business. This is not my business, this is your business. And now, after school hours, you are rolling the BDs. And even during school hours, you're rolling the BDs. Why? Because I'm faking your attendance in the school. That means you're not sent to school, you're basically rolling the BDs. Unfortunately, what happens, even if police comes and wants to arrest you, you can say that this is not my business. These 3 family, they are the owners of this business. Their own kids are helping them in their family enterprise, which is allowed by law. So you are leading to a surrogate business, and this is happening in India. Third problem is, when you're allowing these children to participate in reality TV shows, if there is one reality about the reality TV shows, is that there is no reality. But then unnecessary competition is injected into the minds of these kids at a very impressionable age. Because when there is a child less than the age of 14, they learn quickly, they learn a lot, and their mind is of impressionable age. Whatever you do, that is going to have an impact on these kids, and you're forcing them to learn, to understand, to comprehend this negative competition. Either you are first or you are last. Either you are a winner or you are a loser. As Byjus would say in Three Idiots, nobody ever remembers the name of the person who ever came second. You have to be only first or a loser. That is, this mindset is injected into the minds of these kids at an impressionable age. Unnecessary competition. If these reality TV shows really want to hone talent, why can't there be no winners and losers? But that's not the only problem. When we say that this law allows adolescents, takes care of adolescents, that means these adolescents can work in non-hazardous industry, but not in hazardous industries. Do you know what? Previously, there used to be 83 hazardous industries. And now these hazardous industries have been restricted to only three. Imagine a situation. This is like a jugglery. Previously, there were 83 hazardous occupations and processes where a child less than the age of 14 cannot be employed. Now we are saying this law is a beautiful law because it talks about adolescents as well. Adolescents cannot work in hazardous industries, they can work in non hazardous industries. But previously, there used to be 83 industries which were considered hazardous. Now there are only three. That means the remaining 80, they are non hazardous. That means the adolescents can work in these non hazardous industries, but which were previously hazardous. Which means today you're allowing these adolescents to work in hazardous industries, but it's just that you don't call them hazardous. So it's like you are juggling with the words. And even this number 3 can be brought down to 2, then brought down to 1, then brought down to 0, but not by parliament, but by the government authorities of their own. Which means if tomorrow parliament was given the power that you can reduce this number from 3 to 2, from 2 to 1, from 1 to 0, at least there would be a debate in the parliament. At least parliamentarians will start throwing chairs at each other and say, why are you slashing this number? But no, parliament does not have this power. This power is given to the government. That means the government authorities, bureaucrats, they can slash this number from 3 to 2, from 1 to 0, from 0 to 0. Which basically means no such industry is hazardous. But not just this. Section 3 in clause 5 allows child labor in family or family enterprises, or allows child to be an artist in audio visual entertainment industry. But do you know what's the problem in India? Most of the child labor is caste based. So there is a cobbler who fixes your shoes. He's a Dalit. If you're allowing the child to assist the father in his family business, that means you're perpetuating the same caste based occupation, wherein the son of a cobbler has to be a cobbler, where the son of a sweeper has to be a sweeper. This clause is also dangerous because it does not specify, define the hours of work. This girl who went to school till 4 o'clock now comes back from school to home. After school hours, the law allows you to work, but for how many hours? Does not specify, does not define. Further, government was asked, why have you allowed the children to be employed, to work, to assist in family business, in family enterprise? The answer given by the government was that some of these families, they indulge in art, they indulge in craft, and we need to preserve it. For example, there is a family who is an expert in carpet viewing. For example, there are Kashmiri carpets which sell for 5 lakh, 10 lakh, 20 lakh rupees. Handmade carpets. Similarly, there are shawls, paper mache, wood carving, bamboo making, so many different art and craft in different parts of the country. But it is taught by family. And this teaching how to weave carpet or how to indulge in these craft, this was taught generation to generation by their forefathers. So this art is basically generational. And we need to preserve it. That is why we say you should teach it to your own kids as well. Otherwise, there will come a point where all this continuity will be broken. Nobody will then know how to weave a carpet, how to do a paper mache work, how to do wood carving, how to start making shawls, handmade shawls. This is to preserve art and craft. Why don't you do something else? The same experts of carpet weaving, the same experts of wood carving, shawl making, paper mache, why don't you hire them as teachers in government schools? So that instead of teaching this art to their own kids, they teach it to everybody. And let them also enjoy this process. Let them also develop these skills. And that's how we can make Skill India successful. Artisans should be hired as teachers to pass on traditional knowledge and skills to the next generation. Why only to their kids, to the next generation? That's how we can make this law better. You can write this as a conclusion in your answer. If the amendments intended to preserve Indian art and craft by enabling parents with traditional skills to pass them on their children, this should be done through reform and investment in education. Slash budget should be restored because the budget allocated to school education has been slashed multiple times. Go give it back, give money back to school. Midday meals should be reinstituted. There have been some states where midday meals have been stopped. Secure housing should be provided through Sarva Shiksha Abhiyan boarding schools to homeless children. Those who are homeless, they should be given boarding facilities. And then these artisans should be hired as teachers to pass on this traditional knowledge to the next generation. That is how we can make this law better. That is why whenever a law is passed, first you need to look at why was this law passed. Then you have to look at what are the provisions of this law. Then you have to praise this law. Then you have to criticize this law. And then finally you have to give suggestions, positive suggestions as to how to make this law better. If you have any questions, let me know. Sir, how can punishment be the same for offense 50,000 plus 6 months term? Imposing a fine is not considered to be punishment. Punishment is when you are sentenced to jail. So, child begging on traffic signal is child labor. Depends if the child has been employed by somebody to beg on this traffic signal, then it is violation of the law. And in fact, there have been some states where they have made begging criminal activity. Or any other industry, who will be punished for this? You are allowed to work in entertainment industry. Nobody will be sentenced for that. But if you work in other industry, other than family enterprise, other than audiovisual entertainment industry, then yes, the employer will be prosecuted. Why are you employing this child less than the age of 14? But that's how the law is. How we will meet at where we will discuss articles 25 to 28. But religion is an emotional topic. And while discussing this, I would urge you to keep your religious identity separate, set aside. And I'll start with a disclaimer. Like disclaimer, when a movie starts, all the characters in this movie are purely fictional, and any resemblance to any person living or dead is unintentional. We are not responsible, blah blah blah. Similarly, whatever I'm going to say right now and throughout this discussion on right to freedom of religion, these are not my words, so don't lynch me for this. These are the words of various experts, writers, authors, activists. I'm not responsible for whatever I'm saying. Hold them responsible. Okay. Article 25, freedom of conscience and free profession, practice, and propagation of religion. Article 25 gives us twofold fundamental right: freedom of conscience. And this freedom of conscience is absolute. Because this freedom of conscience is your innermost expression, innermost feeling, innermost belief. And your conscience, your thought process cannot be regulated by anybody, be it a state, be it judiciary, be it any organ, be it any other individual. Your thoughts cannot be regulated because your thoughts are your innermost beliefs, freedom, your conscience. If you have your conscience clear that I am part of this particular religion, that is your fundamental right. If your conscience changes and you want to change your religion and adopt another religion, that is your fundamental right. There can be no restrictions on that whatsoever. Freedom of conscience, your innermost belief to choose a religion of your choice, your innermost belief or feeling, your innermost Australian Supreme Court, known as Jehovah's Witness versus Commonwealth in 1943. The court was asked to interfere in the practices of the Jehovah's, but the court refused. Court said what is religion to somebody is superstition to another. We will not interfere in religious matters because you are free to decide what is good for you, what is bad for you, what is religion to you, what is not religious to you. Australian Supreme Court. But when it comes to the Indian Supreme Court says we will define what are the essential religious practices. And what is this essential religious practice? For that, we need to understand the Sabarimala case. And before understanding the Sabarimala case, we need to understand the Shurur Mutt further came in the Sabarimala case. In Sabarimala case, there is a temple in Kerala which is dedicated to Lord Ayappa. The presiding deity of Sabarimala is Lord Ayappa, and Lord Ayappa is considered to be celibate, brahmachari, or Neshtika brahmachari, eternal celibate. And for that, temple had made rules that women of menstruating age, that means in the age group of 14 to 50, they cannot enter the sacred sanctum sanctorum where Lord Ayappa is situated, where the deity is Lord Ayappa. Why? Because since Lord Ayappa is a celibate, brahmachari, Neshtika brahmachari, eternal celibate, temple authorities have made rules. These rules say that women of menstruating age, which means in the age group of 14 to 50, they cannot enter the sacred sanctum sanctorum where Lord Ayappa is presiding, because Lord Ayappa is brahmachari and we cannot get women of menstruating age to interact with Lord Ayappa. Few women approached the court and saying that this is unconstitutional. This ban on the entry of women of menstruating age inside the sacred sanctum sanctorum of the Sabarimala temple, it is unconstitutional. Women should be allowed to enter the Sabarimala temple. Why? Because it violates Article 14, right to equality. Why should men have all the fun? Why should only men enter? It violates Article 15. There can be no discrimination on the grounds of sex. It violates Article 17 because it talks about some form of untouchability. Women are untouchable. They cannot enter the sacred sanctum sanctorum. It violates Article 21. It violates their dignity. It violates Article 25 because they also have the fundamental right to practice their religion. They want to practice their religion by entering the sacred sanctum sanctorum of the Sabarimala temple. Why? Because Article 25 is not absolute. Subject to public order, subject to morality, subject to health, and subject to other provisions of this part 3 of the Constitution, your fundamental right to freedom of religion can be restricted, reasonable restrictions can be imposed. And now it's for the court to decide whether this ban on the entry of women, whether it is essential to Hinduism or not. If it is essential to Hinduism, it will survive, even if it violates fundamental rights. But if it is not essential, it will have to go because this fundamental right is not absolute. Essential in the sense, if there is one aspect of a religion, which if you snatch, then religion will be destroyed. That is essential. That means for this religion to survive, this practice is essential. Without this practice, this religion cannot continue. But if there are practices which are not so essential to a religion, that means even if these practices are taken away, religion will still continue, religion will still survive, religion will not be destroyed. These practices, if they violate fundamental rights, can be struck aside. But then this case involves interpretation of the Constitution. Whether in reality these temple rules, they violate fundamental rights or not. A 5-judge Constitution bench of the Supreme Court was set up. And there was one woman on the panel. Justice Deepak Misra was part of this. Justice Chandrachud was part of this. And Justice Indu Malhotra, she was the lone women judge on this bench. And the Supreme Court gave a verdict by the majority of 4:1. In September 2018, this Constitution bench of 5 judges gave a verdict 4:1. That means 4 judges were in favor, 1 was against. And 4 judges said women of all age groups may pray at Sabarimala because patriarchy cannot trump freedom to practice your religion. This rule which bans the entry of women between 14 to 50 of menstruating age from entering the temple. This is a patriarchal rule. This rule cannot prohibit this woman group to practice their religion, because they also have the fundamental right to practice their religion and enter the Sabarimala temple. Women of all age groups may pray at the Sabarimala, because the court said on one side, we pray to goddesses, and on the other hand, women of certain age are considered to be impure. This is something that we will not accept. And this rule exacts more purity from women than men. How? When you go on a pilgrimage to Sabarimala, you're also supposed to take a vow of abstinence. That means 40 days you have to abstain from sex and sexual activity. You can't do that because you have to be pure for 40 days. Because Lord Ayappa is celibate, and if you want a darshan of Lord Ayappa, you have to abstain from sex for 40 days. Temple authority said men can easily subscribe to this. They can abstain from sex for 40 days, but and remain pure. But every month, a woman goes through a menstrual cycle, which means she cannot remain pure for 40 days in total, together, in one go. If you are menstruating, if you are of the menstruating age. The Supreme Court said this ban basically exacts more purity from women than men. That is why it is patriarchy, it is unconstitutional. Chief Justice of India and Justice Khanwilkar, they write together. What they say? They say physiological and biological barriers created by rigid social dogma has no place. Yes, there is a difference between man and a woman. Physiologically, they are different. Biologically, they are different. The way they look, they appear, they are different. But then using this physiological difference and biological difference to create inequality in the society is not acceptable. These temple rules, which prohibit the entry of women from entering the sacred sanctum sanctorum of the Sabarimala temple, these are not essential religious practices. That means this is not essential part of religion. And if it is not essential part of religion and it violates fundamental rights, these practices can be set aside, can be declared unconstitutional. Justice Chandrachud said something else. Justice Chandrachud said to treat women as the children of lesser God was to blink at the constitution, was to violate the constitution. And for the first time, Supreme Court expanded the scope of untouchability. Because previously we thought that this untouchability, this term which is in quotes under Article 17, relates to the historic practice of untouchability on the basis of caste, where the members of the Dalit community or the tribals, they were discriminated because of their caste identity, their tribal identity. That is what we thought untouchability is. But now the Supreme Court has expanded the scope of Article 17 and has talked about gender untouchability. Untouchability on the grounds of sex. So these women of the age group of 14 to 50, if they are banned from entering the Sabarimala temple, this is discrimination on the grounds of sex. This is untouchability on the grounds of sex. And since untouchability is abolished under Article 17, and Article 17 says untouchability is abolished and its practice in all its forms is forbidden. One such form is gender untouchability, according to Justice Chandrachud. But Justice Indu Malhotra, the only woman on the bench, she disagreed. She said, what is essential to a religion, what is not essential to a religion? As judges, we should not enter this debate. What is religion to you may be superstition to another. What is objective to you may be subjective to another. What is moral to you may be immoral to another. What is essential to a religion? What is not essential to a religion? Let's not enter into this debate. That is for that religious denomination to decide. So Hindus should get to decide what is essential to us, what is not essential to us. Muslims should get to decide what is essential to them, what is not essential to them. Who are the judges? Because we are not competent to decide on these matters. Because religion is not a matter of logic. Religion is a matter of faith. Faith and logic may not go hand in hand. And this sentiment of justice Indu Malhotra is similar to the sentiment which was advocated by Justice Keher and Justice Nazir in triple talaq case. Justice Keher was then the Chief Justice of India. Justice Nazir, a Supreme Court judge who is right now the governor of Andhra Pradesh. They were hearing a case which challenged the constitutional validity of triple talaq. What is this triple talaq? In Islam, marriage is a contract. In Hinduism, it is not a matter of contract, it is a matter of generations. It's an important sacred institution. In Christianity, they take a vow, till death do us part. That means till death we are together as husband and wife, as couple. But in Islam, marriage is a contract. And just like a contract between two individuals can be broken, even marriage can be dissolved, marriage can also be broken. That means divorce is allowed. But there are various forms of divorce. Through mutual consent, both husband and wife, they agreed that we can't live together, they can separate. But in Islam, the right to grant divorce is given to husband. Only husband can divorce. Wife can only seek divorce. But if the husband says no, divorce cannot take place. But there used to be a process. The process was, husband would say talaq to his wife, divorce to his wife once, and then wait for 30 days. Then if they are still not okay, husband will say talaq again, wait for 30 days. And then the husband would say talaq again and wait for 30 days. Once the 30-day period is over, that means total 90 days are over, the divorce is formalized. But then some innovation was carried out. And that innovation was instant triple talaq. And this was known as talaq-e-biddat. Biddat is an Urdu term, is an Arabic term, which means innovation. That means something which was innovated, something which was not originally present, but something which was innovated later on. And these mullahs, religious leaders, men basically, because men get to decide religion as well, they said, why should we wait for 90 days? First say talaq, then wait for 30 days. Then say talaq, wait for 30 days. Then say talaq, wait for 30 days. Why should we wait for 90 days? We can say these three talaqs together in one utterance. Talaq, talaq, talaq. And the divorce should be formalized. And it was this instant triple talaq which was challenged in the court. The case came to be known as the Shayara Banu. Where 5 judges had to decide whether instant triple talaq is constitutional or not, whether it should be allowed or not. 5 judges were part of this bench: Justice Keher, Justice Nazir, Justice UU Lalit, Justice Rohinton Fali Nariman, Justice Chandrachud, I think, was also part of this bench. So there were 5 judges on this bench. No, the 5th judge was Justice Kurian Joseph. There were 5 judges on this bench. So 1 Sikh, 1 Hindu, 1 Parsi, one Christian, one Muslim. There were 5 judges, but ironically, no woman judge, because there were very less women judges in the Supreme Court to decide on gender issue. Now, the court had to decide whether this instant triple talaq is constitutional or not. And 2 judges, Justice Kher and Justice Nazir, said right to religion is a fundamental right. Islam is a religion. In Islam, you have to practice your religion. And one such practice is you will have to marry as well. Then you can grant divorce as well. And one such form of divorce is instant triple talaq, talaq-e-biddat, which means instant triple talaq is like a fundamental right. Justice Nazir, Justice Kher is saying, since Islam is a religion, right to religion is a fundamental right, and in this religion, talaq-e-biddat is mentioned. That means this talaq-e-biddat or instant triple talaq is like a fundamental right. That means for the first time, a personal law, a personal matter related to marriage or divorce was equated to that of fundamental rights by the Supreme Court. And Justice Kher and Justice Nazir said the same thing. Religion is not a matter of logic. Religion is a matter of faith. And it is for the community to decide what is essential to them, what is not essential. But 3 other judges disagreed. Justice Rohinton Fali Nariman, Justice Kurian Joseph, Justice Yu Lalit, they disagreed. And ultimately, instant triple talaq was set aside. When it was read down, saying instant triple talaq is not legal, because the courts get to decide what is essential, what is not essential to a religion. But in Sabarimala case, the court said, this ban on the entry of women of menstruating age is not an essential part of religion. As such, it does not get protection. Women of all age groups may pray at Sabarimala. But then the review was filed. Whenever you file a case in the court, for example, Supreme Court gives the verdict, you're not still happy with that verdict, you can file a review. You gave an answer copy to me for submission. I said, for this particular question, you got 4 out of 12.5. Then you're sending the mail back, sir, can you please re-review this answer paper to see if you have made any error, to see if something better is mentioned there which you did not notice in the past. I can review that answer copy. Same way, if the Supreme Court has given a verdict, you can file a review petition as well, provided there are 2 grounds on the basis of which your review will be accepted. If facts have been discovered, new facts have been discovered, if you have pointed out an error in that judgment. That means if the Supreme Court has given a Sabarimala verdict, but if the petitioner files a review saying new facts have emerged, or they point out an error in your judgment, new facts have emerged. For example, in this case, since you said these rules are ultra vires of the Constitution, unconstitutional because they violate fundamental rights, they are not essential religious practice. If you can find a new fact, if new fact can be discovered, which was not previously argued in the court, and through this new fact you can convince the court that this ban is essential to religion, the court will accept your petition. We will hear it again. Or if they point out an error, sir, you are saying that there is no such thing as essential religious practice, but in Shirur Math case you said there is essential religious practice, so you have made an error in giving this judgment. We are pointing that error out. The court will accept this petition, will review it. But when this Sabarimala review was filed, no new facts were discovered. No error was pointed out. Yet when this case was heard by the Supreme Court, and this time Justice Gogoi was the Chief Justice of India, Justice Gogoi kept the Sabarimala petition, review petition, pending. We will neither hear this matter nor we will discuss this matter. We will keep it pending. Why? because there are some other similar cases which raise similar issues, similar concerns. Until those cases are also reviewed by the court, judgment is given in these three cases by the court, we will keep the Sabarimala review petition pending. What are these three cases? If women of menstruating age are not allowed entry inside the sacred sanctum sanctorum of the Sabarimala temple, why are Muslim women not allowed inside the dargahs and the mosques in India? Is this also not gender-based untouchability? We will hear this matter first. Second, female genital mutilation, which is practiced by the Dawoodi Bohras. Dawoodi Bohra is a sect in Shia Islam, because in Islam there are two major sects, Shias and Sunnis. Within Shias there are various subsects. One such subsect is Dawoodi Bohra. There is a peculiar case of Dawoodi Bohras pending in the Supreme Court, which we will discuss if there is a need, unless and until something dramatic happens there. Dawoodi Bohra, which is a sect, they have a belief. And what is that belief? When the girl attains the age of 6 or 8, her clitoris is either permanently or partially cut. Why? Because they have a belief that it is this clitoris which is an unwanted skin. And it is this unwanted skin which, according to them, is the source of all sins. They have a belief that once a girl attains the age of 6 or 8, her clitoris is either completely or partially removed. Because they have a belief that this is an unwanted skin. And this unwanted skin is the source of all sins. Is this female genital mutilation essential to Dawoodi Bohras or not? That's for the court to decide. If it is essential, this practice will continue. If it is not essential, this practice will be declared unconstitutional. Hear this matter, then we will talk about the Sabarimala review. Similarly, Parsi. There is a Parsi woman who marries a non-Parsi. That means you have married a non-Parsi. And as a non-Parsi now, as a woman now, Parsi woman who has married a non-Parsi, you cannot be allowed to enter the sacred fire temples and participate in other religious rituals of Parsi community. All these petitions are pending in the court. And all these petitions raise the same important matter. Can religion be patriarchal? Can patriarchy trump the fundamental rights that are allowed, that are provided to the citizens of this country? Justice Gogoi said, we'll keep the Sabarimala review pending till we hear these three cases, and then we will take a call, because the verdict in these three cases will have an impact on the Sabarimala review. Because if in these cases women are not allowed inside the dargahs, if female genital mutilation is allowed, if Parsi woman who marries a non-Parsi is not allowed to enter the fire temple, and if the court agrees with this, then the court should also agree that women of all age groups are not allowed inside the Sabarimala temple, because then we will have to have the same treatment for Hindu women as well. Then some petitioners, once the court gave this order, now listen to me carefully. Once the court gave the Sabarimala verdict, there were some women, some activists, who tried to enter the Sabarimala temple. Already tempers were high in Kerala. No matter who you speak to, they are in favor of women should not be allowed entry inside the sacred sanctum sanctorum of the Sabarimala temple. They claim that these are rules, we have to abide by these rules. There are also some temples where men are not allowed. There are some temples where women are not allowed. So every religion has their own peculiarity. It is just that this temple, you should not allow women. According to Sadhguru, there is something magical in that high energy inside that Sabarimala temple. Women of certain age should not be exposed to that high energy. And that's okay. And since this Sabarimala temple is at a hilly place, there was a restriction for women to not travel this hilly place. Why? Because she may be menstruating, where she may not be in the pink of her health. So for her safety, she was not allowed to enter the Sabarimala temple. But different temples have different rules. There are some temples where men are not allowed. There are some temples where women are not allowed. So every religion should get to decide their own rules. But some women, they were trying to enter the Sabarimala temple, but police decides in Kerala that we will not give you protection. When we will not give you protection, that means some people will lynch you if you enter the Sabarimala temple. These women approached the Supreme Court, my lord, please give us protection. We want to enter the sacred sanctum sanctorum of the Sabarimala temple, but the police is not helping us. Please order police protection so that under police protection, we can travel and pay obeisance at the Lord Ayappa temple in Sabarimala. The court said, what is the need? The tempers are already high. Wait. There is no need. There is no hurry for you to go. Don't worry. What is this attitude of the Supreme Court? This is basically Supreme Court committing contempt of itself. Whether the judgment is right or wrong, we don't know. Whether the judgment is right or wrong, let's not get into this. But it is a judgment after all. And complying with this judgment is never optional. It is mandatory. If a common man would not abide by the judgment of the court will punish that individual for contempt. That's what we discussed. Civil contempt, willful disobedience of a court order. Here the petitioners, whether they are correct or incorrect, whether they are political or apolitical, whether they are mad or in pink of health, we don't know. But when the petitioners are approaching the court, asking the court that please enforce your verdict, the court is laughing and saying, what is the hurry? That is the sad part of this verdict. But ultimately what happened? The Supreme Court said, let's set up a 9-judge bench. We'll set up a 9-judge bench and we will look at all aspects of Article 25, all aspects of Article 26. And this 9-judge bench will have to now rule on certain matters, will have to now answer certain questions. And what are these questions? Question number 1. Article 25 talks about freedom of religion, freedom to profess, practice, and propagate your religion. Article 26, which we will discuss later, talks about fundamental right of any religion to manage its own institutions. So Hindus can manage their own institutions, Muslims can manage their own institutions, Sikhs can manage their own institutions. When you have Article 25 and 26, what is the interplay of these two fundamental rights with other fundamental rights, such as Article 14? On one hand, we say right to equality. But what if temple rules say for men and women there are different rules? What if Muslim mosques and dargahs say for men and women there are different rules? Should we apply Article 14 on these things as well? What will prevail? Is Article 25 and 26 more powerful than Article 14? Can Article 25-26 violate Article 14? Or can Article 14 have more primacy over Article 25 and 26? Because after all, both are fundamental rights. Because it's a matter of equality. Only men have the right to grant divorce, not women. Article 14 is involved. But Article 25 is also involved because you have the fundamental right to practice your religion. And your religion says only men have the right to grant divorce. What will prevail? Your religious right or your right to equality? This is for this 9-judge bench of the Supreme Court to answer. Second, we say subject to public order, morality and health, your fundamental right can be restricted. What is the sweep of this expression? Sweep of this expression in the sense, female genital mutilation, where the clitoris is either completely or partially removed. This goes against the health of the Parsi women. One Parsi actor, Nusrat Barucha, I think I pronounced her name correctly. She was in Israel recently, where she was trapped because there is a crisis between Israel and Hamas. She's also from Dawoodi Boras, and she said, I did not opt for female genital mutilation because my family was progressive. But I've seen people opting for female genital mutilation through force, where this female genital mutilation is not even done by the doctors, is done by unregistered practitioners. And it affects the health of the people as well, health of the women as well. So, in the name of health, court can tomorrow ban female genital mutilation. But what if tomorrow the same sect, Dawoodi Bora, say it is essential to our religion? What will prevail, essentiality or health? That is for the court to decide. Please answer this question. And the court will also have to look at whether we can decide what is essential to a religion or what is not essential to a religion. Can we enter into an area which is beyond our competence? Or should it be left to the head of that religious group itself? You get to decide what you want to practice in your religion. This question needs to be answered by this 9-judge bench of the Supreme Court. Similarly, when we look at the Sabarimala case, particularly specific to the Sabarimala case, do you know who filed these petitions in the court? Not the devotees of Lord Ayappa, but the activists. With full regard to these activists, I bow down to you, all my respect and care for you. But if you're not a devotee, why should you file a public interest litigation saying, I want to pray to Lord Ayappa when you are not a devotee? Can tomorrow Supreme Court accept public interest litigation against a particular religious matter, but this PIL will be filed by someone else not belonging to that religion? Can tomorrow a Hindu man or a Hindu woman file a petition in the court saying polygamy should not be allowed? Polygamy is there for Muslims, not for Hindus. So what is your problem? Can tomorrow a Sikh woman say Muslim women should be allowed entry inside the dargahs? This is a matter that is to be dealt by the Muslim women. Let them come to the court. Who are you to come on their behalf? What would be the permissible extent of judicial recognition to PILs, public interest litigations, in matters calling into question religious practices of a denomination or a section thereof at the instant of persons who do not belong to such religions? That is for the court to decide. And all these matters are right now pending before the court. We will have to wait and watch what the Supreme Court will rule on this matter. But long story short, we have Article 25 of the Constitution. And what is Article 25? It says subject to public order. That means on the grounds of public order, on the grounds of morality, on the grounds of health, and subject to other provisions of Part 3 of the Constitution, which means subject to other fundamental rights. Every person in India, whether foreigner or an Indian, you have the freedom of conscience. That means innermost freedom to choose a religion, innermost freedom from a religion as well. And you can then freely profess, practice, and propagate your religion. But there are restrictions. You can propagate your religion, but that does not mean you have the fundamental right to convert others into your religion. Right to convert is not a fundamental right under Article 25. If you have to convert, for that you can't pay bribe, you can't pay money, you can't force, you can't induce, you can't allure. If you want to convert, you can propagate your religion, so that by propagating you touch the conscience of the people. And once their conscience changes, they should voluntarily change their religion. They should not change their religion because of threats, because of inducements, because of money, because of corruption. But if you have the fundamental right to practice your religion, What if there are some matters mentioned in your religion which conflict with fundamental rights? Particularly Article 14, which talks about right to equality. Article 21, which talks about right to life with dignity. Article 25 itself, which talks about right to practice your religion. What if this is not allowed for women? What do we do? How do we deal with this particular matter? The court in Shroor Math 1954 has said that the courts will decide what is essential and non-essential to a religion. If there is a practice which is essential to a religion, even if it violates fundamental rights, this practice will continue. But if there is a religious practice, if it violates fundamental rights but it is not essential, then it will not continue. It will be struck down by the court. And we will get to decide what is essential, what is not essential. And for that, we have a lot of judgments. Wherein one judgment, Supreme Court said, beard is not an essential religious practice in Islam. Because there was one officer who was a Muslim. After he was appointed, he started sporting a beard. Indian Air Force dismissed him from the service, saying you can't sport religious symbols while you are in Air Force. He approached the court and said, why should a Sikh be allowed to sport a beard and not a Muslim? The court said, beard is an essential religious practice in Sikhism, but it is not essential religious practice in Islam. The court cited the example of APJ Abdul Kalam. He's also a Muslim, but he's not sporting a beard. Nasruddin Shah is a Muslim, but not sporting a beard. Muhammad Ali Jinnah, he was a Muslim, but not supporting a beard. Allama Iqbal, he was a Muslim, but not supporting a beard. So beard is not an essential religious practice in Islam, but it is an essential religious practice in Sikhism. Which means the courts get to decide what is essential, what is not essential. And there are some people who say this is a good doctrine. This doctrine of essentiality is good. Otherwise, sati would have continued. People would have said sati is part of religion, it should continue. But the court may rule if it is coming today, because sati was abolished in 1829. But if it continued today, the court would have said sati is not an essential religious practice. Or untouchability is not a religious practice. Or banning widows from remarrying is not an essential religious practice, because previously even widows were not allowed to remarry till at least 1856, when Ishwar Chandra Vidyasagar played a very important role in allowing the Brahmin widow to remarry, because women of widows of other caste groups could have remarried, but not the Brahmin widow. So it is this essential religious practice doctrine which has enabled the court to uphold fundamental rights and reform a religion. But then there are also others who claim that this is an illogical doctrine, because it tends the court to interfere in matters which are beyond its competence, because you may be competent in law, in constitution, in other matters, but you're not competent in religious matters. Sabarimala case, triple talaq case, Ismail Faruqi case, there are so many instances where the courts have employed this doctrine of essentiality. But then after the Sabarimala case, a rethink is now on the cards in the judiciary. The judiciary has referred few matters to the 9-judge bench of the Supreme Court. And now 9-judge bench of the Supreme Court will have to look at all these aspects. Saying if you have Article 25, you have Article 26, you have Article 14 as well. What if some religious practices violate equality? What will prevail, Article 14 or Article 25 and 26? Because both these sets are fundamental rights. What is the sweep of this expression? Subject to public order, morality, health. Should we review essential religious practices doctrine? Can we accept public interest litigation from Hindus related to Muslim practices, or from Muslims related to Hindu practices, or from activists who are not devotees of Lord Ayappa, yet they want entry inside the sacred sanctum sanctorum? That is for the court to decide. And let's wait and watch what the court will have to say on this matter. Any questions? Let me know. Can't they stay with their religion separately even after marriage? Sir, can we file a case against the person who innovated triple talaq instantly? लाया है हम उन्हें लाएंगे given by party members. Okay. First, the question that one student asked, why should there be a need to convert into another religion after marriage? Can't they stay separately? Yes, they can. For that, we have a law known as uh, the 1954 law. What is the name of that law? Where intercaste, interreligious marriages are allowed. Special Marriage Act. Yes. So that is also there, which we will discuss in Directive Principles of State Policy, where we will talk about Uniform Civil Code. Can we file a case against the person who innovated this thing? We don't know who this person is, because this is the practice which was continuing in so many Islamic countries. But Pakistan banned it in 1960s. Egypt, Turkey, others, Bangladesh banned in way back decades ago. But India could not ban this because of some political considerations. What about this government which says जो राम को लाए हैं हम उन्हें लाएंगे? For that, the problem lies in one judgment of the court, Manohar Joshi versus Election Commission of India, 1998, wherein the Supreme Court has said Hindutva is not a religion. It is a way of life. So if somebody is asking for votes in the name of Hindutva, it is not a corrupt practice. Why? Because the court has said Hindutva is not a religion. Hindutva is the way of life. Justice G.S. Verma was the Chief Justice when this judgment was given. That is why when you say Hindutva, on Hindutva, you're raising these Hindutva issues, it is not unconstitutional. It is not a corrupt practice, because Hindutva is not a religion. You cannot ask for votes in the name of religion, but you can ask for votes in the name of Hindutva, because Hindutva is not a religion, it's a way of life. That is what the court has said. So, do government allow a couple with two different religions for schemes, or anyone should convert? Can you rephrase your question, please? They came to India, they called all those who are living on the side of the Sindhu River as Hindus, because they could not pronounce this letter S. So they call it Hindu. So all those, or Indus, or they called it the Hindus. So it's a geographical term. That is why RSS chief, Mr. Bhagwat, says that all Indians are Hindus. If we look at it geographically, he is absolutely right. Article 26 talks about the freedom, the fundamental right to manage religious affairs. What are these religious affairs? For example, Constitution says subject to public morality, health, and public order. Every religious denomination shall have the right. Every religious denomination, that means every religious community, every religious section, whether Hindus, Christians, Buddhists, Jains, Parsis, Sikhs, Jews, or their subsections, whether Shias or Sunnis, whether Dalits or OBCs, whether Mazhabi Sikhs or the other Sikhs, because there are sects in Sikhism as well, whether the Syrian Christians or the Goan Christians, Catholics or Roman Catholics or others, every denomination, they have a right. What is the right? To establish and maintain institutions for religious and charitable purposes, to manage its own affairs in matters related to religion, to own and acquire movable and immovable property, to administer such property in accordance with the law. Movable property, money, cash, gold, which you can move from one place to another. Immovable property, for example, buildings. Every religious denomination, which means every religious community, their sects, their subsects, they have the fundamental right. What you can do, you can establish an institution. For what purpose? Either for religious purpose or for charitable purpose. For example, there are religious institutions which impart religious knowledge. For example, the mutts, for example, the madrasas, they have the fundamental right to manage them, to establish them. Fundamental right also to establish institutions for charitable purposes. Maybe set up a hospital, maybe set up a dispensary. They have the fundamental right to set these up. And they can also manage their own affairs related to religion. What is managing their own affairs related to religion? For example, there is a mosque. For example, and Muslims have to pay five times a day. And there are timings which are changed or fixed on a daily basis. What should be the time of the morning prayer, afternoon prayer, evening prayer, night prayer, so on and so forth. Can the state interfere and say from now onwards, morning prayer will not be conducted at 5:20 in the morning, but instead will be conducted at 9:45 a.m.? Can state interfere? No. Can state interfere that evening prayers will be conducted at 6 o'clock and not 8:30 p.m.? No. Why? Because every such religious institution has the fundamental right to manage its own affairs related to religion. For example, there is a temple and there is a presiding deity of this temple. When this temple should be open for public darshan, state will not interfere. That's for this religious institution to decide. When this deity is to be fed, state will not interfere. When this deity is to be given bath, state will not interfere. That means in matters related to the religion, this religious institution will manage its own affairs. But the state can regulate secular activities related to religion. What are these secular activities? For example, Supreme Court said in Professor Bhim Singh versus State of Jammu and Kashmir in 1996 that priesthood is a secular activity. This temple, when is it to be opened for public darshan? This temple authority will decide. When should the deity be given a bath? This temple authority will decide. When this deity is to be fed, this temple will decide. What are the hymns that are to be chanted by the priests? That this temple authority will decide, that this religious institution will decide. But who the priest can be, that is a secular activity, can be regulated by the state. So that this institution of a priest is not only open to Brahmins, it is open to all classes of Hindus. That is how in Tamil Nadu, that is how in Kerala, that is how in Karnataka. Now Dalit priests are also appointed. Although this priesthood as an institution was open only for Brahmins previously. Because the state can regulate secular activity related to a religion. Sir, can you give one more example of a secular activity? Yes, I can. There is Tirumala Tirupati Devasthanam. And there, Tirupati laddus are given. These Tirupati laddus also have GI tag, geographical indication. That means, for example, when you buy laddus and you go to a shop and you want Tirupati laddus, they will give you a normal laddu and tell you this is the Tirupati laddu. You would not know. That means ultimately what will happen? Tirupati laddus, they will have a monetary impact. Because in its name, normal laddus are being sold. To prevent this from happening, there is a geographical indication. That means this laddu is a Tirupati laddu. And anybody who violates this, punishment will be imposed on them. Similarly, for example, there is a Pashmina shawl. This Pashmina has a geographical indication tag. That means when you buy a Pashmina from a shop, if it is indication from Kashmir, you should know that this is a trusted Kashmiri product. It is not a fake product. Coming back to Tirumala Tirupati's Devasthanam, can the state interfere that instead of laddu, the temple authority should give jalebis or rasagullas, on which there is a dispute between Odisha and West Bengal? West Bengal says rasagulla is ours. Odisha says no, it's ours. Can the state interfere and say from tomorrow you should provide kaju katlis instead? No. Because every religious institution, it has the fundamental right to manage its own affairs related to religion. But the state can regulate secular activity. Secular activity in the sense, is this Tirupati laddu fit for human consumption? It can be regulated. That means it has to be subjected to FSSAI, Food Safety and Standards Authority of India. Whether it is fit for human consumption or not, that the state will have to decide. State will have to regulate. But can it be laddu or jalebi or golgappa, whatever it is? Golgappa is not a sweet, basically. Any other sweet that the state cannot regulate, state cannot decide, because that is for this religious institution to decide. So what is Article 26? Every religious denomination, which means not just a religious group, but also the sects of that religion, subsects of that religion, they have the fundamental right that you can establish and administer your institution. Whether you want to administer this for charitable purposes or for religious purposes. You can manage your own affairs related to religion. You can acquire movable, immovable property. That is your fundamental right under Article 26, but it is not an unregulated, unrestricted fundamental right. Because in the name of public order, in the name of morality, in the name of health, this fundamental right can be restricted. It can be made in that geographical area. Then how laddus in Tirupati laddus come under TTD? Because the way these laddus are manufactured, the raw materials that are being sourced, they're all unique. And that is why they have a geographical indication. Sir, can you suggest any points in favor of putting the names of consenting couples from different religions wanting to get married in front of the court for 30 days? It's clearly breach of privacy. Yes, it is. But we will discuss this, my dear, in Uniform Civil Code, where we will discuss the Marriage Act as well, the Special Marriage Act of 1954, and how that law basically makes it difficult for people belonging to different religious communities from getting married. We will discuss that, but in DPSPs. But court has not taken any decision yet. The word secular was added to the preamble when? 42nd Constitutional Amendment Act, 1976. Does that mean India became secular in 1976 and it was not secular before that? No, India was always secular. One example that you can give how India was secular, because there was no discrimination on the grounds of religion under Article 15. If India was not a secular state, then on religion there can be a discrimination. Article 16, there shall be equality of opportunity in public employment. When the state is advertising jobs, inviting applications, there can be no discrimination only on the grounds of religion. If there was a discrimination on the grounds of religion, if the public offices were available or open only for Hindus, then it was a Hindu Rashtra. It was not a secular state. If it was available only to Muslims, then it was an Islamic state. It was not a secular state. But the most beautiful example, illustration, why India was a secular state even before 1976 is Article 27. For example, during the Mughal period, although Akbar tried to abolish this, but it was reinstated by Aurangzeb, jizya, tax was imposed on non-Muslims so that the state can protect them, protect their property. For that, they will have to pay tax, and that tax was known as jizya, which means tax for a specific religious group. Such a tax cannot be imposed in India today. Why? Because Constitution says no person shall be compelled to pay any taxes, the proceeds of which are specifically appropriated for the promotion or maintenance of any particular religion. That means a tax such as jizya in 2023, in 1950 onwards, can never be imposed because that would violate Article 27. We have something known as cess. What is cess? It's basically a tax, but for a particular specific purpose. For example, Swachh Bharat cess, Krishi Kalyan cess, education cess, health cess. That means when this tax will be imposed, it will be used only for that purpose. That means whatever money is generated through health cess, all that money will only be used for healthcare facilities in India, will not be diverted to any other purpose. When the tax is imposed, cess is imposed on Swachh Bharat cess, for example, then whatever proceeds we receive by imposing this cess, whatever money we generate, whatever money state generates, will not be used for any other purpose, but will be used for Clean India campaign, Swachh Bharat Abhiyan. Can tomorrow the state impose a cess such as Ram Temple cess? Which means whatever money is generated will be used for the construction of a mega Ram temple at Ayodhya? No, such a thing cannot happen. And this is what clearly emphasizes, underlines the secular identity of the Indian Constitution. Freedom as to payment of taxes for promotion of any particular religion. But the taxes that you and me pay, they go to ensure security of those who come for Kumbh Mela. They go for the security of also those who go through the Muharram procession. They go through the security of those who also go on a Kailash Mansarovar Yatra. Yogi ji says, whoever votes for me, I will take them on a pilgrimage to Kailash Mansarovar Yatra. Arvind Kejriwal says, why should Yogi have all the fun? If you vote for me, I will also send the elderly couple to Kailash Mansarovar Yatra. But for the promotion of one particular religion? No. We will give you subsidy for those who go on a Hajj pilgrimage as well. Although that has been stopped now, but even that money is used for the promotion of the education of the Muslim girls. So if there are some specific schemes which are specific to the minorities, religious minorities, that means the money that you and me pay in the form of taxes is used for the education of minority girls. Then this money can also be used for sending children or for sending elderly to Kailash Mansarovar Yatra. And BJP had a different manifesto promise to people of Meghalaya as well. That if you vote for us, once we come to power, we will send people to Jerusalem. That means in India today, taxes are used for the promotion of not any particular religion, but for all religions, directly or indirectly. That is Article 27 of the Constitution. One, such a tax such as jizya only for a specific religion cannot happen. That means tomorrow there can be no such tax as only Muslims will have to pay the taxes. Hindus are exempted from income tax. This cannot happen. This is violation of Article 27. But the taxes that you and me pay can be used for the promotion of any particular religion, all religions, not any particular religion. That's Article 27. Clear? Constitution is what Supreme Court says it to be. So Supreme Court can do anything except convert a man into a woman or a woman into a man. Or the Supreme Court is so powerful that it can do even this. That is something that we will discuss in Supreme Court when we will discuss this chapter. Why Hajj subsidy is unconstitutional? It was not unconstitutional because it was based on the discussions with the Muslim community. They voluntarily agreed that we should not be given subsidy. Why? Because when I told you about the 5 principles of Islam, the 5th principle was if you have the means, if you have money, then you can go on a Hajj pilgrimage. That means only those who can afford should go to Makkah. And why should government give you subsidy for air tickets and hotels if you have to go on a pilgrimage? Because it is not meant for you if you don't have means. Instead, that money can be used for the education of the Muslim girls. Hindu is primarily a geographical term. Whoever resides in this geographical area is a Hindu, geographically. But then Hinduism is also, although people say that you should not call it Hinduism, it should call it Sanatan Dharma. So Sanatan Dharma is basically a religion. Equally, well, that is debatable, whether it should be equally administered or not, equally spent or not. That is debatable. As codified in the form of Sharia law. They have a written constitution, but they draw inspiration from Sharia by mentioning those provisions in their constitution. Right. But what is the question? On religious affairs. That means matters related to religion. When the deity should be given a bath, when the deity should be fed, when the deity is open for public darshan, that you can manage on your own. That is religious matter. Okay, so let's stop here. We will meet tomorrow again, hopefully.